Okay, everyone. Ooh, that's nice and loud. Come on in, lean in, grab some cheese, grab some beverages, stay at the table if you like, come and move around. This is what we refer to as the winter salon setting, but it feels nice and warm and toasty in here. So I hope you're very comfortable, and then we'll get ready and get started. So good evening, everyone. Welcome to Eastern State. We're so happy to have you here. My name is Kerry Sautner. I'm the president and CEO here at Eastern State. And tonight's program is around the Eighth Amendment. It's called Excessive Punishment, and really examining what that Eighth Amendment means, what has it meant over time, and its intersection with not only the general public, but also the site of incarceration. We are on a site of incarceration. And here at Eastern State, we preserve America's first penitentiary to ensure that this preservation and the work we do examines how we understand the justice system and engages people in a dialogue to make a fair and just system as we move forward. So this is the work that we do here. We do it through programs like this called Justice 101. We do it through daytime tours. We do it with programs across the country, including our entire team this Friday and Saturday will be at National Conference of Social Studies. Nathan, are you going as well? Great. So there's going to be 5,000 social studies teachers hanging out in DC over the weekend. So if you want to nerd out with a bunch of social studies teachers, take the train down. But it's amazing work that we do. We do it on site. We do workforce development. All of these pieces really matter. So tonight's conversation grounds us in that history, grounds us in the conversation around Eastern State, but also brings into that conversation, where are we seeing this dialogue today? Where are we seeing interactions and questioning from the community around what is excessive punishment, and are we meeting it? So I have two amazing speakers with me tonight. I'm honored to introduce them both. Let me begin with Kermit Roosevelt. Kermit is the David Berger Professor for the Administration of Justice at the University of Pennsylvania Carey Law School. He is the author of numerous law review articles and several books, most recently, The Nation That Never Was, Reconstructing America's Story. That is a fantastic book. I want to pause for a minute because it's one of my favorites. I love Reconstruction. It is absolutely a wonderful book to read, and I'm really sorry because I meant to bring it. And it's sitting on my kitchen table right now, Kermit, so apologies. But right over there, we have QR codes for both of their books. So if you want to get a great read tonight, we have two great reads for you. Kermit has also written many other books, and it is an amazing professor and one of my favorites to talk about the Constitution with. He can talk about the colonial Constitution and the founding of the Constitution, as well as Reconstruction. So Kermit, thank you so much for being here.
Thanks.
Next, we have L.B. Eisen, is the Senior Director for the Brennan Center's Justice Program, where she leads the Brennan Center's work to end mass incarceration. Before joining the Brennan Center, Eisen was a senior program associate at the Vera Institute of Justice, where she worked on the sentencing and corrections team to implement policies in multiple states to improve public safety while reducing prison populations. LB is a fantastic ally in this field. On a daily basis, I'm pretty sure I'm looking at both of those organizations to look at the data that they look at and the effects that it has on policy. So when you're really diving into what do we see today and how is it affecting people in our community and across this country, you want to check out the Brennan Center and the Vera Institute. She wrote an amazing book, or edited an amazing book with lots of different authors called Excessive Punishment. So perfect theme for tonight. There's a couple copies over there if you want to take a look at them, and a QR code for the book as well. So thank you, LB, for being here as well. So it's wonderful to have you both here, but Kermit, you know I always like to start with the Constitution. So could you kind of, for the entire audience, and we have, people in front of us, but a couple hundred people online as well, and we'll be taking questions towards the end, both in person and online. Could you give us a little framing about what does the Eighth Amendment say, and what was the genesis behind it being in the Constitution? We'll add it with the Bill of Rights.
Sure. So I think there's a lot to say about the Eighth Amendment. I'm a sort of general constitutional law professor, and one of the things that I like about the Eighth Amendment, and the reason that I spend some time on it in my class, even though I'm not actually a criminal procedure or a constitutional criminal law specialist, I spend some time on it in the general constitutional law course, because I think it illustrates maybe three really significant things. which I won't give a full discussion of now. But one, I think it's very important for thinking about originalism and constitutional interpretation. And two, I think it's very important in understanding the relationship between the founding and Reconstruction. As Kerry said, that's one of my big interests. That's what my last book was about. And I think it shows us in a very vivid way how the nation changes and how our understanding of the structure of our Constitution and the relationship between the states, the national government, and the people changes during Reconstruction. But just to go back to the beginning, the Eighth Amendment is part of the Bill of Rights, which was added to the Constitution in 1791. And what the Bill of Rights does basically is it's trying to respond to the pervasive fear at the time. If people are thinking we don't want to ratify the Constitution, why are they thinking that? Generally, it's because they're worried that they're creating a national government that's going to have too much power. And they're thinking back to the oppression of King George and Parliament. There's a national government that had too much power. It was behaving like a tyrant. That's the whole reason for the revolution. Following the revolution, of course, we get the Articles of Confederation, where there really is no national government. There's no executive branch. There's no judiciary. There's a Congress that can request money from the states and coordinate them in some ways, but can't actually enact laws that bind individuals. So really nothing in the way of a national government. And now this Constitution has been proposed. It's creating a much more robust central government that can actually do lots of things, and people are concerned this government's going to become a tyrant. So the Bill of Rights has a bunch of provisions that are designed to make that less likely by, in some cases, empowering the states. The Second Amendment is an example of that. It's trying to empower state militias, but also by putting limits on what the federal government can do. So one of the things that the Bill of Rights in the Eighth Amendment says the federal government can't do is impose cruel and unusual punishments. And there's a big debate about what that means, and that raises some of the themes that I was talking about. But I won't really go into that now. I'll just say it looks as though, and this is sort of the way that the court has interpreted it, it looks as though it's trying to bind the federal government by reference to what the states are doing. So the federal government can't go too far away from what states think is appropriate punishment. So if there's a punishment that's unusual, right, not a lot of states do it, and it's unusual because it's cruel, states think that it's excessive or barbaric, and that's why they don't do it, then the federal government can't do it either. So it's trying to set a floor below which the federal government can't go. It sets that floor by reference to state practice, and then the interesting question is, like, can the floor move? Is this an elevator that could go up and down? That's the question about originalism, but we'll get to that later.
I can't wait to get to that, actually. I'm so glad you already teed that up, because the Eighth Amendment is always the one that, to me, feels the most malleable. And I think that's really important. So when we talk about cruel and unusual punishment, LB, can you talk a little bit about your work and how do you define that, and where are you seeing that work and that research today around what is excessive punishment? Because it feels very opinionated what excessive punishment could mean, and how do we balance that as a society and in a nation through our laws?
Yeah, absolutely. And thank you again for having us here today. It's great to be having this conversation here at Eastern State Penitentiary. There's so many people who specialize in the Eighth Amendment or Eighth Amendment scholars, and I can talk a little bit about some of the essays in this book. And the Brennan Center published this book. We curated these essays called Excessive Punishment, How the Justice System Creates Mass Incarceration, and actually stemmed from a series of essays that were on our website where we called them punitive excess. And truly that phrase comes from Jeremy Travis and Bruce Western, who helped curate a lot of these essays as well, and had been talking a lot about this idea of punitive excess. And every time I said excessive punishment, they said, no, it's punitive excess. And it's this idea that we didn't put guardrails on the criminal justice system in every single aspect of the system. And the concept is we went too far in terms of the punitiveness in this country. And so we thought that it would be great to enlist academics, practitioners, advocates, formerly incarcerated people, currently incarcerated people, to weigh in on this idea of punitive excess. And authors wrote about policing, they wrote about probation, they wrote about imprisonment, solitary confinement, federal funding that for so long has actually incentivized states to incarcerate more people. And every single author was asked to wrestle with this idea of where were the guardrails? Could there have been guardrails at any point in our history? And that's really what sort of the inquiry of these essays is about. And I think a really good example of this, we talk so much in, when we're discussing the criminal justice system about punitiveness, about disproportionality, and those are all related to, what is unjust about the system. What does punishment look like? What punishment is too much? What punishment works? I mean, we're still wrestling with these questions. Eastern State Penitentiary was wrestling with these questions from its start. What type of punishment will rehabilitate, will reduce recidivism? And so those are what the essays focus on. And if you think about collateral consequences, I always like to highlight that because it's so real and concrete. There's a great essay in this book that highlights the more than 40,000 collateral consequences that one can be subject to just for having a conviction. Sometimes the consequences are, one can't get public housing, you can't find a job, you can't vote, you can't engage as a full citizen in your community. You might not be able to get a driver's license, you might not be able to get a state ID, you might not be able to get educational opportunities. And these 40,000, there used to be a website that actually listed all the collateral consequences, and it was just people were adding to it every single day because there's so many. You can't get certain licenses, like in some states you actually can't get a barber's license even though you might be trained as a barber once, if you're incarcerated. In California, you all probably are very well aware that incarcerated individuals in California are a huge part of the firefighting apparatus in that state. For many years, even though they were trained and working at these jobs when they were incarcerated, they weren't eligible to become firefighters. Now they are. The law changed in California, and that's good news. But all of this is related to this idea that we are uniquely punitive, I think, as a democracy. If you look at a lot of other democratic countries, punishment is the restriction of your liberty, right? A judge, a barrister, someone sentences you to a time behind bars. And then once you enter that correctional facility, you focus on normalization, you focus on rehabilitation, you focus on skill building, you might wear street clothes, you might have a library in the facility that's the same library that your family members have access to in the community. Your doctors are often the same doctors that your family members, friends have in the community. That is so different than what happens in the United States and how we've always treated incarceration and punishment. And we are very, very uniquely punitive in how we not only punish people once they receive a sentence to spend time in a jail or a prison, but also what happens when they're released. And so would urge everyone to read the great essay about collateral consequences, the criminal justice debt that people suffer because they might leave prison with debt, with fees from the fees from being charged for various items. Sometimes you have to pay for your sentence itself, for your bed, for your stay, and that is just sort of unheard of in most other democratic countries. So I'll stop there, but the book really builds off this idea that so much of the punishment in the United States is wildly disproportionate to the harm that was actually caused.
So there are so many directions I want to take on that. I almost feel like
It's not concise.
No, it was great. It was both of you are absolutely wonderful. But I just need to echo that line that you said. Punishment is a restriction of your liberty. That is such a powerful line. We launched this year early for the 250 a year of liberty, and because that is so much when we talk about a site like this, a site of injustice, a site that restricts liberty. We so often, when we talk about the founding of our country, when we talk about Reconstruction, we talk about establishing justice. We talk about liberty, life, happiness, all these things. But we never talk about the flip side of that, which is when do you take away somebody's freedom? When do you take away somebody's property, somebody's life, somebody's liberty? We tend to always talk about the receiving and not the detracting, but that is what our society does. Kermit, I kind of want you to talk a little bit about Mason and like the definition in the Virginia Bill of Rights around like it is to the government's job to ensure that its people have safety, have prosperity, have liberty. And yet we have a justice system at the time today that is not actually creating a more safe society. It is restricting in a way that I believe the framers would freak out about people's liberty. And for example, here today, so the idea of Eastern states starts in 1787. It's early May. And it's Benjamin Rush, Ben Franklin, a few others get together. And they're like, what are we going to do about Walnut Street Jail? It's a very, very violent cage holding people, children, women, men, all different sorts of violence, all these pieces. And they come up with this idea that we should do something different with justice. And some of the things that they do is they say, you're not going to have a long prison sentence. It was typically under 2 years. That you would come in and nobody would know your name. Even the guards, nobody would know your name. You came in with a cover and you were numbered the whole time. That's a World War I plaque. And you see all those numbers because they didn't codify somebody's name. Not just because they didn't want you to know who they were, but when you went home, that you didn't have a badge and incidence, a scarlet letter of incarceration. And yet we're not seeing that today. And this is what they were grappling with when they were defining liberty for our nation. They were also thinking about how do we remove liberty and is it fair? We'll talk about how they came up with a really bad idea of solitary confinement. We're not gonna let that go, but let's turn over to you, Kermit, a little and give us that framing around the Eighth Amendment, around excessive punishment and how that's changed over time. And how do you find a balance over American history? You talked about the elevator going up and down. How do you find that? I'm just going to bring in the standards of decency, that kind of theory around it.
Well, I think those are really interesting points, and you get a very interesting perspective on this if you sort of go back to the founding and George Mason and the Declaration of Independence and John Locke even, and think about it from that perspective, because you do have this very widespread sort of boilerplate Enlightenment political theory at the founding, and this is why Jefferson, although apparently this was Franklin's edit, can say that these are self-evident truths in the Declaration, this theory of the purpose of government. So the theory is the purpose of government is to protect your natural rights, the rights that you would have in a state of nature if there were no government and no laws. And liberty is a very uncontroversial one of those. So the idea is, in a world with no government and no laws, you would have your natural rights, but they wouldn't be secure because other people might come along and violate those rights. They could steal your property, they could restrain your liberty, they could kill you and take your life. So governments are instituted among men to secure those rights, as the Declaration puts it. And the purpose of the government is to protect your liberty. But it does that, of course, by putting limits on what people can do. It enacts some laws. And everyone understands that you can restrain some people's liberty in order to prevent them from violating other people's rights. So you can have laws against theft. You can have laws against false imprisonment or kidnapping. You can have laws against murder. And that's okay. And then the interesting thing is that apart from that, apart from the protection of natural rights, people at the founding, and this is a strain of thought that you still see going into the present, are very, very negative on the idea of the government interfering with your rights if it's not to directly prevent a violation of someone else's rights. And the way this really comes out is maybe less with liberty and more with sort of property and anti-redistribution. So, at the time of the founding, they'll debate whether Congress can enact disaster relief and spend money from the general treasury for the relief of people who've been hit by a hurricane or a fire or something. And a lot of people are saying, no, government can't do that because you're taking from people who haven't done anything wrong and just giving that to other people, and you're violating the rights of the people you're taking money from, not to protect someone else's rights, but just because you think that's a good idea. And this anti-redistribution idea sort of persists through American history. This is why the Supreme Court invalidates progressive wage and hour laws, because you're interfering with liberty for no good reason, just because you're trying to make someone better off. This is kind of the argument against affirmative action, that you're putting burdens on people who haven't done anything wrong just to lift up other people. So there's a very strong current of individualism and protection of individual rights there. But then at the same time, if you do break the law, it sort of flips. And suddenly you're like outside the political community and your interests don't count anymore. And technically, like, this is what outlawry is. So you do something and you're an outlaw, you're outside the protection of the laws, you're not one of us anymore, and we don't care about your rights. And you can see that happening, like, not technically with outlawry. We don't say you're not protected by the laws anymore. But once society categorizes you as a criminal, suddenly your rights and your interests definitely don't count for so much anymore. And one of the things that I do when I'm talking about judicial review with my students in the early days of the class is I say, usually we don't like judges second-guessing legislative policy choices or the ways that legislatures balance cost and benefits. Right? We want legislatures who are representative bodies to decide what's a good idea. We don't want judges deciding what's a good idea. But the extent to which you're comfortable with judges second-guessing legislators maybe has something to do with the groups that they're dealing with. So then I say, do you think that it makes sense to have enhanced judicial protection or judicial solicitude for laws that burden the interests of, say, black people? And the students were like, yeah, that does make sense. Or women, right, or gays and lesbians. And the Supreme Court has done this for most of these groups. And the students are like, yeah, I see why that makes sense. And then I'll say, but what about, like single malt scotch drinkers or rich people? And the students were like, no, those groups can do fine in the ordinary political process, right? They're not going to be treated worse than they deserve. Right? And then I say criminals. And the students are always sort of struck by that, and they're puzzled and they struggle with it. Because yes, of course, everyone has this intuition that criminals do deserve to be treated worse than non-criminals, right? Which I think is true, because they broke the law. But if you're asking the question, do they get treated worse than they deserve? Then I think absolutely the answer to that is yes. And if you look at the criteria that the court has used to identify groups whose interests don't get adequate weight in the ordinary political process, or groups who really need special judicial protection, criminals actually fit those criteria pretty well. But we don't have that special judicial solicitude. This is a vulnerable group that society is prejudiced against. And they absolutely do get treated worse than they deserve. And we don't have very much in the way of judicial solicitude, even though, we've got the Eighth Amendment there, suggesting that this is something courts should be worried about.
And that's a fascinating way you frame that. Like, I've never thought about that as that protected group, to look at that and say, should this be a protected group? And you're right, it sets up all the structure, the power dynamics, all the systems to question that. But there is that, again, that societal belief that it shouldn't be. And you also pointed out, like, the difference between how the Bill of Rights, for example, applies to you. And we all know that it's always different. It's not, everybody gets the First Amendment equally. It's not time, place, manner, totally changes things. But how the Eighth Amendment applies to you before you're convicted and after you're convicted. So LB, this is really kind of the question around when we talk about excessive punishment. Probably most people in here and online are thinking like stockades, like tar and feathering, like that's what your brain goes back to. But that's the punishment that is doled out. there's also the bail, how long your stay is, your punishment is, and how you're treated, and what is the punishment internally in a prison system, in an incarcerated system. And for this site, connecting it back to solitary confinement, that when they experimented this before it opened at Walnut Street, they knew that solitary confinement created major mental health issues within 2 weeks. Now, they're not using those words, they're using different words, but they knew it was so damaging to the human mind that you can see in the court record judges writing no more than 2 weeks in the experimental solitary confinement of Walnut Street Jail. And they still went through with this, and they still opened it up and kept solitary confinement on the record until 1913, before that probably around 1877. But where are we seeing that in the incarcerated setting, not just in sentencing, but in treatment?
So I'm going to read a quote from the book, which is, I'm quoting the late law professor Robert Ferguson, who wrote an incredible book in 2014 called Inferno, an Anatomy of American Punishment, which I would suggest everyone read if you haven't read it yet. And he wrote, "The instruments of punishment are carefully divided. Legislatures create criminal statutes. Police use them to arrest. Prosecutors charge. Juries decide. Judges pronounce sentence, and prison officials carry out the sentence. The approach to punishment is multifaceted in the name of fairness and objectivity, but it serves as an exculpatory purpose as well. The separations in the function of punishment mean that no single official ever has to look directly in the abyss. No one punisher need feel the full burden of creating suffering." And I quote that in the introduction of this book because I think it's such a powerful description of our justice system. And you mentioned, there's sentencing, then there's punishment. And in the book, it's sort of divided up into the sort of chronology of punishment a little bit, but there's this sense of pomp and circumstance and procedure and due process when you are in front of a judge, and hopefully you have a public defender, there is a hearing, there is a stenographer, there is a judge wearing a robe, there is a prosecutor, one is sentenced, and then the judge loses track. We don't have we don't have a criminal justice system where judges are checking in on people that they sentence and incarcerate, right? The public defender is probably too busy. The prosecutor is certainly not doing that. And then someone may be sentenced to, lengthy periods of time when there's very little oversight of incarceration in this country. And prisons and jails are very untransparent places. It's very hard for families to get information about what's happening inside, the media to get information about what's happening inside. And, I really think it's so important for us as we think about how our justice system has evolved to think of the justice system not as one system, right? There's a sort of a pre-sentencing system, and then there's punishment and what that entails, and then there's post-conviction or post-incarceration and all of the collateral consequences that people are suffering that often may bring you back into the system because of the debt, because you can't get a job, because you are still suffering from the same, driving factors that got you incarcerated in the first place. And we also have a country where we have, more than 3,000 jails, more than 1,600 prisons, more than 1,000 juvenile facilities, dozens upon dozens of immigrant detention centers, and a state system, a federal system, a local system. So when we think about the criminal justice system and how it's evolved, it's become huge, right? Every single state has jails, has prisons. Many have federal prisons. Many have juvenile detention centers. Many have immigrant detention centers. And so as we seek to improve the system, it's incumbent on all of us to think holistically about the system. And I think I've sort of lost track of your original question.
Doing great.
But it's, people always think about there's one criminal justice system in this country, and there's just not. It is so complicated. There's been some messaging research done on how to connect with voters, with the broader public about the system. How do you explain this complex system? And something that resonates with a lot of people is a maze, right? If you explain what a maze is like, and that you can't really get out of the maze, it's very complicated. That's what the criminal justice system is like in this country. And so you had asked about bail and all of these other sort of aspects. They're all interrelated, but they're all these sort of unique complexities that just sort of pile on a very punitive approach to punishment.
No, I think you actually answered that question perfectly, because the question was really about how do we see excessive punishment playing out in the criminal justice system today, and that was a perfect visual too. It's like a sticky maze in a web that you're constantly trapped and getting more, stuck and more connected to it every single interplay that you go through. And I guess the question that I go back to is, you're talking about this, and again, this site is so powerful when we have programs here, because it does really help frame it for people. They started this, and again, went very wrong in so many ways, but they started it with this respect for human dignity. That the belief, it was a Quaker starting, and that the belief that every person had an inner light, and that's why there's so many skylights to remind you of that inner light and to call to it, and that we could always get back to who we are in nature, and that is somebody who's good. That's human dignity. And if this belief, and at this time in America, there's not a lot of jails, there's not a lot of prisons. The big ones are very few. There's less than a half a dozen. And so if we start with this idea that everybody has human dignity and we just need to get back to that inner light, that inner good, and if that is the original purpose of giving people back their liberty, and the purpose is to get back to good, get back to wherever you got lost, do we have the same system today? I'm not saying that they did that well, but what is the purpose of incarceration then? And we know, of course, the purpose is to ensure that people aren't victimized. But this system should also be, and a question, does it also really serve justice? Meaning, does it serve reform? So I'd love to ask you both that.
I can quickly answer that, and then you can also respond. So the Brennan Center actually has a report coming out early next year looking at innovations in prisons across the country. And one of the driving questions we've been asking in this report is, do these programs, do these jurisdictions focus on human dignity? And there is reform happening in the US right now. The criminal justice system, the history is sort of this pendulum swing between reform and punitiveness, and one step forward and 10 steps back. So there are pockets of change in red states, blue states, all across the country. But this idea of human dignity is not one that the modern criminal justice system embraces. So Germany, for post-World War II, actually enshrined human dignity is inviolable in their constitution. It is not in the U.S. Constitution. And in fact, in Germany, many of the corrections officers there actually go visit concentration camps because they learn about power. They learn that absolute power corrupts. And they have a lot of power as officers in these facilities. They go through 2 years of rigorous training. In the U.S., correctional officers may go through a couple of months, sometimes less, sometimes more of training. And human dignity is not often part of the curriculum, treating people humanely. I know here people didn't have names for a different reason. Now, in many prisons, incarcerated people are called, inmate number, 25. There's something called dynamic security that is common in Northern European countries, and a lot of jurisdictions are starting to embrace and practice right now, which is a different type of managing prisons and engaging individually with the incarcerated people under your care. But human dignity is just not a driving force in how we treat people who have committed harm in this country. And, we can talk for decades about why that is. But the sort of politics of punishment are very, very difficult in the United States. And there is this idea of punitiveness really has always been more powerful than this drive to provide human dignity in punishment in the U.S.
It's fascinating too, and I think one of the other things about the German officers, because Commissioner Ramsey, who was a former Philadelphia police commissioner, always ensured that in D.C. and in Philadelphia that all of the recruits went to the Holocaust Museum. And one of the key reasons for that in Germany and under Commissioner Ramsey was so much of people who were identified in small towns were because the local police knew who they were in Germany and in other cities. That was the human community connection that put people at more risk. And so not just the position of power, but the position of power when you're a part of a community and how dangerous that could be. And Kermit, to kind of pull that idea of human dignity and back in, I guess one of the questions in kind of balancing around this, I always think of Miranda. And the Miranda case, and putting the Miranda case in front of the court and in front of the country, when you dig into who Miranda was in that case, Miranda's not a great person. He's very violent, but they picked that case to say the government does not do this. So how do you connect the role of the Constitution and human dignity, and also knowing that the word freedom is also not in the Constitution, just so we get clear there too. So how do you make that connection around the role of human dignity and our United States Constitution?
Wow, tough question.
Sorry.
So many interesting things. So one, Miranda was a bad guy, and Miranda got his confession excluded. They convicted him anyway. Right? There was enough additional evidence that he had actually done it, which I think is an interesting point, because you might then ask, well, gosh, what is the point of constitutional rights that, this guy's guilty? And, if you say exclude evidence that's been illegally obtained, you're only helping out guilty people. So what's the point of all of this? And the thing that I try to tell people about that is that, if you're a lawyer in court and you're arguing for the Fifth Amendment rights of your client or something like that, in a sense, of course, you're defending your client, and that is your job as a lawyer, to zealously represent the interests of the client, and even guilty people deserve lawyers and all of that. But there's also a sense in which you're defending not just the client, but the client's rights. And the rights that the client has are the rights that everyone else has. So one way of putting this, I sometimes say, is that the guilty are the first line of defense for the innocent. Because if the government can do these bad things to the guilty people, they're going to be able to do them to the innocent people too. Because you don't know whether someone is innocent or guilty until you go through the system and do it all properly. And if the government can cut corners to get the guilty people, they can cut corners and get the innocent people too. Which doesn't really answer your question, but I have a couple of things that more directly... You went to
where I wanted you to go, so it's perfect.
More directly relate to it. And so one was, and this is actually going to be a question for you, but I don't want you to answer right away, although I do want to hear it later. So one was, as I was hearing you talk about the history of this place, I was like, wait a second, I'm not sure I understand what kind of a monument I'm in here. Because on the one hand, we've got sort of interesting historical sites that are architecturally cool and historically significant. And like Benjamin Franklin's house, that's interesting. Or even places where we wouldn't do the things that they did anymore, like an old surgical theater where they operated without anesthesia or something. Wow, that's interesting. And then there are what you could call negative monuments. So the never again places, this is a place where terrible things were done that we should not do again, concentration camps or the detention camps for Japanese Americans. And I always thought of this as hey, the Quakers had nice ideas and they were trying to do good things, and this is sort of interesting and architecturally cool, and you can come here on Halloween and do Halloween nights. But then some of the things that you were saying made me think, wait, maybe this is actually more, or at least it has elements of the kind of negative monument. So I wasn't sure about that, and I would like to hear what you think. But then I want to go on to one more thing that came to mind while LB was talking and while you were talking, and it does have to do with human dignity and the extent to which the Constitution protects human dignity. Because I think the answer is, particularly with the Eighth Amendment, not very much, or not as much as we would really like it to. Because thinking about the criminal justice system as a web, I think, is a great image, and it's a very vivid image. And then the image that I would counterpose to that is like the image of the torturer. So the torturer is like deliberately doing bad things to a particular person on purpose and, you know, maybe for a bad reason. And the founders are very concerned about that. And the Eighth Amendment is really about the torturer. The Eighth Amendment is about the government cannot torture you. The government cannot do these barbaric, cruel things to you. And that's good, right, because they shouldn't be able to. But that, and this is what LB was saying, I think, that is not the only way in which the criminal justice system inflicts harm on people. And you can do a lot of harm to innocent people, you know, before they're even tried. If you confine them so they can't work and they don't have enough money to get on a bail, and there are all of these things that will really hurt you. And, you know, maybe the conditions of pretrial confinement are terrible. And does the Eighth Amendment protect you against those? Well, in some ways it just categorically doesn't, because they're not punishments. It's just the way the system works. So it's not the torturer, it's the web. And the government can say, look, we're not punishing you. This is just our system. And then even afterwards, when we are talking about punishment, there are like all of these collateral consequences and things that build on each other that just sort of collectively weigh you down and rob you of your dignity. And the Eighth Amendment really doesn't protect you against that. And then talking about the question of the purpose of punishment, then, you know, absolutely, I think, you know, you want to do something that people think is unpleasant so that other people won't commit the crime, and that's your general deterrence. And maybe you want to do something that's going to incapacitate someone so they can't commit crimes for some period of time, and that's specific deterrence. But also you would like to rehabilitate the person so that they're less likely to offend in the future. And there I think we really do a terrible job. I think just about everyone comes out of prison worse than they went in. So rather than rehabilitating, we're having the opposite effect. And you know, I think that for better or for worse, that kind of plays into jury decisions, actually. So, you know, people told me, oh, now, like, you're a lawyer, you'll never be seated on a jury. And then they were like, oh, now you're a constitutional law professor, you'll never be seated on a jury. I was seated on a criminal case. Yeah, I was seated on a criminal case, and I got to hear the jury deliberations and participate in them, where there was, you know, the government was prosecuting this young kid for something that actually I think they didn't really demonstrate was in fact a crime. He ended up being acquitted. But the other jury members were not really focused on, did the government prove each element of this crime beyond a reasonable doubt, which is what I was thinking about, because that's what they're supposed to do. Instead, a lot of them were saying things like, look, this is just a kid. You put him away. When he comes out, he's really going to be someone you have to worry about. He's not a bad kid now, but he's going to be a bad man if you put him in jail for 5 or 10 years. And, you know, so for better or for worse, I think that's like something the juries think about.
It's funny, going almost to the constitutional methods of the outcome of the decision in some ways. I just want to commend you for answering that multi-part question, every single part. Both of you are doing a really good job, but right now I'd like to turn it over to the audience's multi-part questions. So Joel is going to walk around with the mic, and if we have questions online, Kerry, just raise your hand and Joel will come over to you as well. So does anybody have a question for one of our two brilliant panelists here? There we go, right over there.
Good evening, thanks. I guess I'd like to get some reflection on the inequities in the manner in which the justice system gets meted out, with specific regard to the Eighth Amendment, let's say then. I'll leave it wide open for the panelists.
Great question. So the inequities of the Eighth Amendment being applied to people. Either one of you want to go for that?
I mean, I can start out and just talk about one specific example, which is the death penalty. So it is, there's so much research that indicates the death penalty is implemented in a racially biased, disparate way. And, you know, when people, I mean, there are Eighth Amendment concerns about the death penalty. And, you know, as we talk about the evolving standard of decency, which we haven't spent that much time on tonight, but I know is always on all of our minds when we think about the Eighth Amendment and punishment. There's so much public support right now to eliminate the death penalty across the country because that research is reaching the broader public. Innocent people have died, you know, by the hands of the states. And we know that the death penalty as implemented in this country is incredibly racially disparate. We know that the number of people who are incarcerated, you know, if you look at prisons and jails across the country, Black and Latino individuals are overrepresented in the criminal justice system, in our jails, in our prisons, in our arrest rates. So there's a lot of racial bias that we need to always be aware of when we talk about the criminal justice system. And certainly, you know, you mentioned juries. Juries are an important part of our democracy, but we have also had a sort of storied history of jury service in this country where juries have meted out very disproportionate punishment based on the color of the skin of the defendant in the courtroom.
Yeah, so I would say I agree there's a lot of racial bias in our criminal justice system. And then from a constitutional law perspective, I would say the Eighth Amendment, I don't really think does anything about that. The more promising line of argument is probably the 14th Amendment's Equal Protection Clause. But even that doesn't do as much as you might hope, because the way that the modern Supreme Court has interpreted it, you really don't get an equal protection issue unless you have an explicit racial classification. So if what you have is a pattern of jury decision making, but no one's explicitly saying it's about race, the Equal Protection Clause really isn't going to help you. You know, maybe it would form a basis for congressional action if Congress wanted to do something, but judges are not going to step in and stop something. Or if you have laws that are facially neutral but have a disproportionate racial impact, if you've got, for instance, a really wild disparity in the way you impose sentences for crack versus powder cocaine, and that's got a racial impact, the Supreme Court is going to say, well, there's no racial classification, you know, we don't really see the problem here. And it's sort of ironic. I mean, ironic is maybe too charitable. I think it's just sort of bizarre. Because it is true that there used to be explicit racial classifications in the criminal justice system. There used to be things that were crimes or not, depending on your race, or there used to be crimes where the penalty that was imposed on you depended on your race. And absolutely it's good that we got rid of those. But we did get rid of those a pretty long time ago. And more recently, the cases in which the Supreme Court has been considering racial classification tend to be cases where the government is trying to reduce inequality through something like an affirmative action program. And the most effective way to do that, obviously, is to use a racial classification if racial inequality is what you're concerned about. But recently, most of the Supreme Court cases about the Equal Protection Clause have been saying that's exactly what you can't do. Right? You can't consciously consider race in trying to redress racial inequality. Or, you know, even sort of more strongly, a desire to redress racial inequality is not a legitimate government interest. For basically the reason that I was hinting at before, because the court thinks you're putting a burden on people who haven't done anything wrong in order to help out some favored group, and that's not something the government should do.
Thank you. Very good. Any other questions? There we go. Now we come in. Everybody needed a minute. Okay.
Thank you so much for what is a lively and in some ways devastating in the complexity and challenges that you've outlined. Thank you for all of that in this conversation. My question is, what is the relationship between, so backing up, I was really interested in this distinction that Professor Roosevelt made about punishment is, what was the phrase? It was, what I heard was the singling out of the torturer to an individual. So that means that that person is treated unlike all the others, and that is singling out for punishment. And I guess I'm wondering what the relationship of the Eighth Amendment is to excessive use of force in more extrajudicial situations where I guess we can't call it punishment because the person's not even in this web yet. And I guess my backstory in asking this is on my way over, I was reading about a fairly detailed look at the boat attacks and sort of where the crime lies with, you know, was it the initial strike on the boat? Was it the killing of the two people hanging onto the boat? What does military law say? And again, that action is coming via the executive branch. So where, and I'm not a lawyer, so where is the Eighth Amendment within some of these questions? Thank you.
Well, yeah, so again, like the answer, I think, is the Eighth Amendment is not there as much as you would like it to be. It's not a general excessive force remedy because the Supreme Court has said it has to be a punishment. And I was suggesting, you know, this is something they have to do to you on purpose. That's not quite true. Deliberate indifference can also amount to an Eighth Amendment violation. But it does have to be a punishment. So if, you know, the police use excessive force during an arrest, that's maybe a Fourth Amendment violation. That's how they tend to analyze it because it's an unreasonable seizure. They're like, well, you know, if they detain you and beat you, that's a seizure, and that's the question. Or there could be a more general standard. There's like a shocks the conscience standard under the Fifth Amendment that will come in sometimes as a catch-all if no other amendment is relevant. It's a little bit complicated with respect to the boat strikes, as some people will say non-citizens outside the country don't actually have constitutional rights, which I think is wrong, but this current Supreme Court is maybe interested in that. But there are still laws. You know, there is laws of war so that, you know, killing an incapacitated enemy is actually a war crime. And because I don't think there's any plausible argument that this actually does fit the definition of war under international law, it's also like just murder.
Thank you.
And not related to the boat strikes, but just in general, there are also federal statutes that protect individuals when their civil rights are violated under color of law. So if a correctional officer, a police officer violates someone's civil rights, you can use federal statutes to, you know, those people can be prosecuted by the federal government. And then there are also some statutes where people can actually file suit themselves as well. So there are lots of ways that one can try to achieve justice in excessive force situations, depending on what the situation is.
Thank you. That was a great question, too.
I think we have a couple of online
Okay. Want to do an
questions.
online question? Okay. And then we will wrap up because I know we're getting there.
Okay, awesome. Professor Roosevelt mentioned that juries are supposed to determine guilt, but well over 95% of criminal cases are resolved with a plea agreement. The prosecution never has to prove anything beyond a reasonable doubt. What role do you see plea agreements playing in excessive punishment?
I think I was going to say, LB, you can jump in here too on this one.
I can jump in quickly on this one. So I'm a former prosecutor, and most of the cases were pled, and it's because of resources. I mean, there just are not enough public defenders, enough prosecutors, enough judges to actually take every single case to trial. But in terms of the question, it's a great one because there's something called the what many of us refer to as the trial penalty, which is a prosecutor will often say, okay, look, if you go to trial, I'm going to charge you, top count, felony, top felony. The sentence could be, 5 to 10 years. But if you take this plea deal, I will charge you the lowest level felony, and I will tell the judge, time served is adequate here. And for a lot of defendants, they cannot take that chance, even if they're innocent. So when we look at, and there are a lot of organizations that are, National Association of Criminal Defense Lawyers, ABA, there's so many organizations that are working to try to end this trial penalty, and there are some prosecutors' offices that have actually decided that they're not going to allow their prosecutors to, make those deals anymore. But it really is a resource issue, and it's also a justice issue because so many people are not, the government doesn't actually have great evidence in a lot of these cases, but people cannot jeopardize spending years, decades, losing their families, losing their jobs in prison, and so they will take a plea deal, even if the government has terrible evidence, would never win the actual court case, or if the person's innocent. That happens a lot too.
Kermit, do you want to add anything?
Well, I agree with all of that. I would just say, to me, this sort of illustrates the gap between theory and practice, because if you look at our constitutional system, in theory, wow, it's great. You've got these individual rights. Gosh, the government can't push you around because you've got a right to a lawyer and you've got a right to a jury trial. And then even if they do convict you, right, they can't do something terrible to you because of the Eighth Amendment. But again, like in practice, you're probably going to plea bargain. And if you go to trial, it can cost you enormously, even if you're acquitted. And if you're convicted, there are lots of terrible things that will happen to you that are sort of invisible to the Eighth Amendment. And a lot of those things might happen to you even if you're not convicted. So in practice, the system just inflicts immense harm that's sort of invisible if you're thinking about it from this idealized, this is our great Constitution that we learn about in high school perspective.
And I think that's unbelievably powerful. Both of you really explaining, like, we see this theory, we see this ideal, and at the same time, we know that the ideal is not being brought to the fruition. So that's perfect. It brings us all the way back to the beginning, around the 250, this ideal, this visionary belief of the Declaration of Independence, that we have this big vision for our country, and then that we have systems like the Constitution and laws and policies and practice that put it into play. And so to wrap this up, I'd love just a real quick, one of the things in our mission here is to ensure that the work we do is meant to inspire a more just future. So not just leaving people with what are the issues and where are the questions, what can you do about it? And so if we have this visionary document and then we have this process materials to get us through it, at the end of the day, we're the power in that government. We energize it, but we also have to hold it to the guardrails or hold it to the system change, to that reform. So what can we do about it? So go for it. Not an easy one to answer either, sorry.
I think something that all of us can do is think about who we're voting for. And we often think, presidential elections, but you vote for your city council members, you vote for your local legislators, you vote for your district attorney, you vote for so many people you vote for your governor. Your governor appoints your correctional director. And then that has a whole trickle-down effect on how every prison in the state is run. So when we think about the criminal justice system, I work at the Brennan Center, and the Brennan Center works to improve our systems of democracy and justice. And the reason why we have a justice program at the Brennan Center is because it is a failure of our democracy that our justice system is as broken as it is. So write op-eds, go to your city hall meetings, go to your state legislative meetings, and really exercise your right to vote. And we often talk to college students, high school students, who may not realize that voting at the local level carries so much weight in terms of, what your justice system will look like in your county, in your municipality, in your state. I mean, that's one thing you can do.
It's great.
Yeah, that's more or less exactly what I would say. I think like state and local politics,
That's why I went first.
because that does have an impact, and I think it can be done, because I think a lot of people are sort of content with the status quo because they were taught this idealized version of our constitutional rights and our justice system, and that's what they see on TV, maybe in Law and Order and Special Victims Unit or something. And if you inform them as to what the reality is, oftentimes they'll be like, wow, that's not living up to our ideals. And people do like the idea, I think, that we're going to hold the government to the promises that our founding documents make. That's like Martin Luther King, I have a dream. And so I think that there is a real potential to get people informed and get them motivated and make changes at the local level that are going to make real differences in the way that criminal justice is applied.
Excellent answer. And you both made me think of something I read today, that there is a piece of legislation going through City Council, and it's on training of security guards. And part of, so check it out. I think Isaiah Thomas is moving forward. But I thought of that today, like when you were talking, like that's an escalation. And we don't think of security guards as a part of the justice system, but they can easily lead to the justice system. If we escalate instead of de-escalate, it goes from kids running through the gallery to kids getting arrested at the gallery. We look at our education system and where those actions are caused all throughout those pieces. So really powerful. And a part of it is informing each other and learning more of it. Our work here is about advancing the public understanding of the justice system, and that's a part of it too. So learning, sharing, getting the word out, but then also taking steps and actions to it. So I can't thank you both enough. This was a fantastic conversation. We definitely have to have part 2 where we go deep into standards of decency. And we will also, in the future, have a program where we really talk about this site. To back to your question about what is it, it's so much like humanity. It's a dilemma. It's multiple things at the same time. It is a site of trauma. That is kind of the word that you were thinking of it, but it is also a site of hope and resilience and resistance. We were talking about that in the beginning. There were women incarcerated here that raised each other's children. So when they went home, they took the babies that were born here and held them and raised them for their mother until she came home. Wherever humans are, we can see terrible pain and unbelievable hope and resistance. And we see that in our government structures, and we see that in the checks and balances, but we also see it in everything we do. So it really is dilemma and complex. Just like we say about the Constitution, it's definitely complicated. But thank you so much for all being here tonight, and can we give these two a huge round of applause?